We are here today because on October 22nd, 2024, this man, defendant Carlos Fisher, assaulted his wife, Stacy Fisher, by telling her that he would light her ass up, and then he raised fist as if he were about to get her. I anticipate that complainant Ms. Fisher will testify that this happened at 6-1 Michigan. At that time, I believe both parties were residing in the house. You will hear, I anticipate that you will also hear from the party's adult child, Ms. Carlos Fisher, who was present during the incident. She was present in the home during the incident, but she did not see what happened. I anticipate that she will testify that she heard defendant tell complaining witness, or that she heard defendant tell Ms. Fisher that he would light her ass up. I anticipate that you will hear a recording of a 911 call where Ms. Stacy Fisher calls 911 to tell police that defendant just threatened to light her ass up and assaulted her. And I know Judge already touched on this, I'm not going to belabor it too much, but for an assault, in this case, defendant is charged with 1 count of domestic violence. In order to prove that, I have to show first that defendant assaulted Stacy Fisher. An assault is an attempt to commit a battery or an act that will cause the reasonable person to fear or apprehend an immediate battery. And a battery is a forceful, violent, or offensive touching of a person or something closely related to him or her. So in this case, the assault would be defendant raising his fist as if he was going to punch Ms. Fisher. And I have to show that defendant had the ability to commit a battery, and that Ms. Fisher reasonably believed that he had the ability to commit a battery, so that Ms. Fisher reasonably believed that defendant had the ability to punch her at that time, and that defendant intended to make her fear. The next thing I have to prove is that the parties were married at the time of the offense. I anticipate again that Ms. Fisher is going to testify as being married to the defendant. Like I said earlier, this is a simple case. Testimony is evidence. I anticipate that after you hear testimony from Ms. Stacy Fisher, her daughter Ms. Carlos Fisher, and you hear the 911 call, the totality of the circumstances will lead you to conclude beyond a reasonable doubt that defendant assaulted Ms. Fisher on October 22nd, 2024 by raising his fist at her as if he was going to hit. Thank you.
Mr. Hadley now.
Yeah. Ladies and gentlemen of the jury, you got a task in front of you today. It's pretty straightforward. So as you've all agreed during our jury selections, to keep an open mind and carefully listen to the evidence, listen to what you hear, listen to what you don't hear. Listen to what evidence will be missing today that you think would be really helpful if you're trying to make a decision to hit that burden of beyond a reasonable doubt. Now, ladies and gentlemen, as you're kind of digesting what the prosecution just told you today, we are in agreement about one thing. This is a case for domestic violence, and there's been no allegations whatsoever, any actual physical contact. Nobody was pushed, nobody was kicked, nobody was shoved. No one picked anything up and threw it at anyone. There was no physical contact made. What we're talking about today is assault by apprehension. Fancy word of saying, I committed an act and I had the ability to follow through with that act. That act put you in a reasonable fear that I was going to offensively, harmfully touch you. Think back to the playground, the old tooth or flinching. You know, you pull your hand back and your buddy actually cowers because you're going to hit him. That is assault by apprehension. Ladies and gentlemen, that's the prosecution's case. That's what they're telling me. Is that my client committed an act that a reasonable person, objectively, what the reasonable person put in that position would have felt was basically putting them in immediate fear of being harmed. Not that what happened hurt their feelings or it was a really lousy thing to say, or that the family was going through a lot, or that the marriage was breaking down. All those things don't matter. The only thing that matters is you really listen to the evidence today is you have to make the determination, did the people prove that very, very high burden that there's evidence beyond a reasonable doubt to show that this man's actions put his wife in reasonable fear of being harmed. Now, I want you to think about, baseball answered truthfully earlier about what do we do when we look at people to try to figure out, are they giving the whole story? Somebody can be telling you the truth about one thing and lying to the teeth about something else all in the same breath. We've all had that happen. You can tell me it's Wednesday and also tell me you're gonna pay me on Friday. Be right on Wednesday and be lying about paying me on Friday, right? So it's gonna be really important as we go through this to very carefully scrutinize what was said, who was where, and what happened. And I want you to think about what these words that were said actually mean. Now, I want you to really think about, hear this evidence today as we move through it. Does it make sense? Call the sniff test. Pass the sniff test. Does that make sense? Do you believe that you presented with enough evidence to hold the individual who's presumed innocent so the government can meet that extremely high burden of beyond a reasonable doubt with their evidence? Now, there's going to be a story that's told today. And ladies and gentlemen, I believe the evidence will show us exactly what it is. Take the department back to my grandma. Well, she had great sayings. They worked. You had a really nice sweater, just got a little string sticking out. Little thread. You can't tuck that in, right? Keep your arm down, nobody notices. What happens when you start tugging on that thread? That sweater comes undone. And ladies and gentlemen, I believe if you follow me through this path today, walk with me, Mr. Fisher, down this path, as the evidence is presented to you, that you're going to start feeling that tug. You're going to start feeling that gentle tug in the sweater. Well, at first, it sounds fairly plausible. But when you look at what you hear, when you think about credibility, who's saying what, it's very, very important to think about how that sweater's looking as that thread continues to get tugged on. But we start to see holes. Ladies and gentlemen, I propose to you start seeing any holes. That's that right there. Your job's done for today. It's not your job to put the evidence forward. That's her job. It's just your job to put that evidence on the scale and say, does it show you this man committed the alleged act he's being accused of? One of the things that no one's really talked about yet today, it's very important as you go through today's process. Motive. Right? Very few of us, if we're sane people, do things for no reason, right? We don't just willy-nilly run out and do stuff. I mean, when we're teenagers, maybe. Young adults, maybe. But as we get older, we start to be a little more calculated, a little bit more deliberate in our actions. I think we'd all agree on that. You carefully calculate things a little bit differently. The problem with the lie, ladies and gentlemen, is that it builds on top of itself. You start out with a, pardon my French, but a BS story. There's no fix. You can't cure it. You can kind of spin it and you can kind of jump to another spot, but you can't fix the original problem. And I firmly believe today when you watch and listen to what's being said, and again, what order things happened in, who was where, who was doing what, I feel confident. And I said I'm nervous because this is serious. I'm nervous because it means so much to me and my client, but I am confident. You're all more than capable. From the statements you made under oath today to the judge, the prosecutor, myself, you guys are up for this task of looking at the evidence, sifting through it, and making a determination. Now, ladies and gentlemen, you're going to hear some evidence today that's, I don't know, it just kind of sucks. It's rough. Family was going through some tough times. We said before, Mr. Fisher and his wife, they had a spot. You're going to hear testimony that supports that. Now, I believe you're going to hear testimony today, ladies and gentlemen, that will give you a completely alternate theory as to why somebody may have made an accusation that somebody would have verbally threatened them in a way that got police involved. Now, you're going to hear more testimony today that says once an individual is arrested for a crime, a domestic violence crime, the very next step is for police officers to remove them from their home. The miracle. You're evicted. No judge, no 7-day notice to quit to get out of your house. Best case scenario, a couple days later, You're gonna be given a police escort to walk back and grab about what you do here. So as you're thinking through, why would somebody ever? Why? Why would somebody say something that's untrue, be willing to come in and risk such a serious wrongdoing as lying? Lying to the police, why would they get to there? It doesn't mean you're a bad person. We all talked before, emotions happen. I'm not here standing today to tell you that after the evidence comes out today that the complainant, that Mrs. Fisher is a bad human. I'm not here to say that she's a bad person. I'm just here to tell you that emotions got the better. She, I believe the evidence will show you, felt that she was in a situation where she was in a marriage that she was unhappy with. You're gonna hear testimony that she didn't have enough money to move out or to get a divorce attorney. And you're gonna hear that she made that decision that night to involve her daughter in law enforcement to remove my client from his home. Because she felt that was just gonna be the easiest way to get this. Ladies and gentlemen, I implore you, again, be open-minded, careful, and as the judge told you, if you have questions, don't forget to use Officer Crow. My client and I are more than happy to address everything. We look forward to this day, to be in court. He's not in fear of this, he's nervous, certainly, just like home. But no one's in fear of this because this is the day, finally, the accusations. The baseless accusations that had nothing more than words behind them are finally going to be brought in front of somebody who is neutral, who doesn't know the parties, who hasn't been involved with these folks before. You can look at it and make your own decision. I thank you all for letting me share this with you. I look forward to speaking to you again as this day goes on. Thank you.
Ms. Mandernack, are we ready for a witness?
Yes, sir. People call Stacy. So I identified the people who just requested forgiveness as well.
Okay. Is this lady a witness?
No, this is Mona. Our victim man.
Okay. Stacy Fisher is your first witness?
Yes.
Didn't. What do I deal with it? Ms. Fisher, all the way up front, please. Ma'am, watch your step right here. There's an incline ramp. You raise your right hand. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth today? Have a seat right there in that chair. Make yourself comfortable. Good.
Thank you. Morning, Ms. Fisher.
Good morning.
Can you please restate your name for the record?
Stacy Fisher.
Okay. And just a couple of ground rules. When you're answering questions, I need you to verbalize your answers so the microphone can pick everything up. So no, no head shaking, yes, no, etc. I want you to keep your voice up, please, so that the microphones can record everything. I always feel like I'm shouting in court, so I want you to shout at me. The correct answer is the honest answer. There are no trick questions. If you don't know the answer to something, that's fine. Just tell us you don't know. If you don't understand a question or need me to repeat a question, because sometimes I talk fast, so you know, okay?
Yes.
Okay. Ms. Fisher, I'm going to take you back to October 22nd of 2024 at about 11 p.m. Where were you? Okay, I'm sorry. Could you just speak a little louder or you can bring them up?
I just got home from work.
Okay. And where is home?
6112 Swan Lake Drive.
And is that in the city of Romulus?
Yeah, Northwest Michigan.
Okay. And where do you work?
Well, I have several jobs. I work at, DTW, airport. I work as a security officer there. I work also as a cosmetology instructor. In the city of Detroit. I also work at my church as a director of our children's ministry. And I also work at JCP Hair Salon. That's sport.
Okay. Where were you said you were coming home from work on the night of October 22nd, 2024. Where had you been working that night?
I had been working at Metro Airport.
Okay. And, do you recognize anyone in the courtroom today?
Yes,
Who do you recognize?
Carlos Fisher.
Can you please point to him and tell us something that he's wearing?
Carlos Fisher is wearing a white jacket.
Your Honor, yes, the record.
Noted.
Thank you. And, Ms. Fisher, how do you know Carlos Fisher?
Carlos Fisher is my husband.
Okay. Was he living with you on October 22nd, 2024?
Yes.
Okay, and can you describe the home at Swan Lake Drive to us?
It is a 3-bedroom, 2 bathrooms, colonial type home with an attached garage.
Okay.
And a large deck area on that.
Okay, who was in the home that night?
I was in the home. Carlos was in the home. And our daughter was in the home.
Okay, what's your daughter's name?
Carlos Fisher,
Okay, and how old was she at the time of the incident?
19.
Okay. And, what happened when you got?
Well, when I got home that night, I could not get in the garage. Normally when I get home, I can usually use my garage door opener to get in the garage. That particular night, well, before that, my garage door opener came up missing. And so every time I get home, I have to call someone to open the garage for me. Or get out the car and press the keypad or something like that. That particular night, I was so tired. I just pulled it up in the garage, in the driveway. I sat there for a few minutes and then I said, let me grab all my bags, get out the car. And as I was getting out of the car, Carlos was coming out of the house through the garage door.
Okay. Had you called him? You said, that you had to call people to get in because your garage door opener, you either didn't have it or it wasn't working. Did you call him to let you in that night?
No,
Okay. Did you have the garage door opener with you that night?
no. I had been missing for months.
Okay. And what happened when he came out of the house?
I had already grabbed all my bags, which was a lot of different heavy stuff. So I had already grabbed all my stuff, had stuff on my shoulder, hands, and I was walking up the driveway. He was coming out of the garage, we were walking towards one another.
Okay, was he saying anything as he was walking towards you?
I don't know if he was saying anything as he was walking towards me, but when we got close, he said that he would move my car.
Okay.
I'm already in motion, tired, ready to get in the house. And he said, I'll move your car for you. I told him, don't even worry about it. Gotta work early tomorrow, I'm the first one out, so just let it sit. I'll just pull out tomorrow. And so at this point, I asked him, he's walking behind me back into the house. And he's asking me for a key. Give me keys, I'll move the car. Give me keys, I'll move the car. And I'm like, just don't worry about it. No, don't worry about it. I'm out tomorrow. By the time we get in the house, he said, you heard me tell you to give me the keys. Why didn't you give me the keys? And I'm like, as I'm putting my stuff down, I'm like, cause I wear my keys on the lanyard around my neck. So I'm like, I'll just give him the keys to move the car. But before I can do that, now he's mad.
Okay, can you, I'm sorry to interrupt, can you describe his demeanor at this point? His
Well,
body
at
language?
that point, he was, getting kind of loud and boisterous about me not giving him the keys and not moving fast enough. You heard me tell, this is what he said, you heard me tell you to give me the keys, why didn't you give me the keys?
Okay, and what happened next?
I was standing at the table. Where I usually, we have like our dinner table in front of our day area where the glass doors are. And so I was standing in the spot where I usually eat, which is where my back is against the glass, towards the glass. And I was standing there getting ready to hand me the key. He was ranting and stuff, he probably didn't even, I don't know, he was mad at this.
Okay, and what happened when you were standing near the dinner table?
Oh, he was cussing me out and stuff, and then he raised his fist up, like he was gonna hit me in my face, like he was gonna come down at my face.
Okay.
And stopped close to my face.
Okay, how far away was he from you, when he raised his fist up?
Like,
Or where was he?
right here, he was on my left side. Like close, like the fist was coming like this.
Okay, was he on the same side of the dinner table as you?
Yeah.
Okay. And, I believe you previously, can you show us again about how far away he was from you?
Like, where this thing is right here.
Okay, Your Honor, the complaining witness is touching the side of the.
So-
I'd
Can we agree that's within 18 inches?
I'd say within 8 inches. That was just,
Well, I guess depending on where we're gonna measure, from her shoulder.
oh. I'll stick with 18
Your
inches.
Honor, if we, objection, I just, how do we ask her how many inches away do you believe his fist was?
Well, that's not the question. The question, the question was how far away was he? So was he closer than that juror?
Yes.
Was he half the distance between you and the juror?
He's like right here.
Okay. So if you would have done this, you could have hit him. If you would have stuck your elbow out, you could have hit him.
Oh, yeah.
Okay, so within a foot or so.
Okay, thank you. And you said he raised his fist, did he say anything when he raised his fist?
Yeah, he said, well, after he stopped himself, he said, I mean, he's gonna do it, cause you're a cop. And what you gonna do is call the police.
Okay. And when he raised his fist, did he move his fist towards you?
Yes.
Okay. How close did his fist get to you before he stopped?
Like, right there, 4 inches.
Okay. And what happened next?
I just did it. Because that's scary. That scared me, so I just stood there and people started, when he backed up, he started walking around, throwing insults, stupid, and stuff like that, right? And so, trying to think exactly what he said, because he said,
Well, let me interrupt you. Did he threaten you in any other way that night?
yes,
How did he threaten you?
after he stopped himself from eating, he started walking around the kitchen, calling me names and stuff like that. And then he walked closer over to where the garage door meets the house, where we go in and out from the house to the garage. He was standing there. And as he was walking over that way, he said something about he could be my ASS or something like that. And so, since he was away from me, I said, no, you won't. Beat me and beat you back. That's what I thought. And when I said that, he turned around, he had on a roll, gray roll. He turned around, he put his hand in the roll pocket, and like he had a gun. And he said, I'm gonna light your ass up. He started screaming, I'm gonna light your ass up. And he had his hand in the pocket like there was a gun in there. I was terrified at that point, because I don't know. This is not the first time he has threatened.
I found we stopped right there. Did you know whether or not he had a gun in the robe pocket?
I did not see a gun.
Okay. And, what happened after he said he was gonna light you up?
My daughter was coming in,
Okay,
and his back was to her. And she said, when she opened the door, she said, who you gonna light up?
okay,
And he turned to her and said, no, just move, let's go over these cars.
okay, and what happened after that?
As soon as he walked out that garage door, I did exactly what he said I was gonna do. I called the Romulus Police Department. And I stayed on the phone with that dispatcher. The whole time he was in the garage, I was giving my account, telling them, I need a police officer to get here right away. The dispatcher stayed on the phone with me until they came.
Okay,
Well, even beyond that.
okay, I'm gonna back up a little bit. When you first got home, was your daughter home?
Yes.
Okay, do you know where she was in the house?
No, I was outside but eventually came outside to move her car as well.
Okay, was she in the house when, Mr. Fisher raised his fist at you?
No,
Okay.
she had taken her car. Sometimes we take our car down the road to turn, make a U-turn to come back around and pull in the garage. And so she had been out to do that. She was not there for any of the argument or anything like that. She came up when, as she came up, all she could hear was, I like your ass up.
Okay. And you stated that you called 911?
Yes.
Okay. Your Honor, I would ask to publish what I would admit is stipulation as People's Exhibit 1.
Your Honor, we have no objection other than unless you're gonna be at the timestamps that you discussed.
Didn't discuss timestamps for,
Well, that would be the,
because I don't think we discussed timestamps for this.
we didn't, so that would be my objection would be that, I have no issue with the video being played as stipulated to, with the exception of the standing objection we'd already raised during our motions to eliminate.
Judge, make that complimentary play approach.
Sure.
Yes, I'm real number one, I'm responsible for. And I just wanted to touch Mr. Smith's supposed to make sure. I was just asked for a problem in the.
You do that when you.
Yeah.
We can go off, you wanna make sure you remember what it said.
Thank you for that indulgence, Your Honor.
So while you two nail down the timestamp, I'm gonna explain the stipulation to the jury that we discussed. Yeah. So, if Mr. Hampkins was here, I'd let him explain it because he's been in so many jury trials. So you've watched TV shows. All right. So quite often when one side wants to submit some evidence, there's got to be a long foundation for the evidence, and the other side argues whether or not these two have stipulated that certain things are going to be submitted to you today. So, for example, what we've talked about, I'm not sure it's all going to come in, but what we've talked about is a 911 tape, or recording, I should say. That's how old I am. They used to put them on tape. A 911 recording. There's also some conversation about some body camera footage. Well, what the stipulation, which just means agreement, what they've agreed to is certain portions of that 911 recording or those body cameras are relevant for today, and certain portions aren't. So you might hear some conversation, and then there might be a pause where it's muted, and then you might hear some conversation. You might see some video where certain parts of it are paused. That's because they've agreed, the attorneys have agreed, that certain parts are relevant today and certain parts aren't. So I don't want you to get hung up on why aren't we hearing what we aren't hearing, because they've agreed that it's not relevant for today. Understood? Thank you.
Trying to make good progress, just please bear with us for.
Yeah. It's better than a foundation. I mean, this stipulation's quicker than laying the foundation. Oh, let's talk about this too. And it's already lunchtime. We don't break for lunch until you guys want to break for lunch, if you want to break for lunch. All right. So from the conversations I've had with the attorneys prior to getting started, I think this one's going to move fairly quickly now that we started the actual testimony and everything like that. So we'll just work until you say, hey, you know what, Judge, it's time for us to take a break. And then we can talk about how long a break you want. Fair enough? And that, I mean, that doesn't mean you guys all have to be in lockstep. If just one of you think, hey, Judge, I think we need a break, then I'll let you break as a group, decide what you want to do. And then I'm going to tell them that's what the jury's decided. All right.
We're halfway through the sentence. What have you allowed me to acknowledge you? Thank you, Your Honor.
Or when you're ready, Ms. Bandernack.
Your Honor, permission to publish People's Exhibit 1.
Absolutely.
As this has been stipulated, so I have actually no objection to Ms. Mandernack, Prosecutor Mandernack explaining what the evidence we're about to play is, just for the jury to have full context of what we're talking about.
Thank you.
And I think you already clarified just with, we're working to my full call.
This is just audio right now, right?
Yes.
All right.
Okay.
Yeah.
If we can remove, if we can make sure there's no video play, that actually.
Yeah, we're good.
Plug in HDMI in. Am I?
Okay, what's going on? Did he actually hurt you? Yeah, okay, he or did anything to you? Okay. Are you gonna say Barry? Where is he at?
I'm sorry, Mayor, I'm gonna restart this in an easier way to comply with our stipulation. Since I don't have to share my screen. Sorry.
Where's your emergency? Okay, what's going on? Did he actually hurt you? Yeah, okay, he or did anything to you? Okay. Are you gonna say Barry? Right, where is he at? Where is he at right now? I'm sorry. Okay, and where are you at? Six of three, okay, actually, on week. Oh, what's his name, man? Did you see the gun? Okay. Are you able to leave? Or, no, I'm sure you're still responding, this is just to keep you safe until you get there, until they get there. I understand, you just, are you leaving a vehicle or anything?
I don't know.
Are you able to- Okay, so tell me about this vehicle, what kind of vehicle is it? You are.
And I'm gonna pause real quick at 3 minutes. Ms. Fisher, who is that talking? Carlos. Okay.
Okay. Did you prepare the seat again? Okay, did he own any weapons, any firearms? Yeah, what kind?
Your Honor, I'm stopping it at 4:55. And I'm gonna restart at 5:04.
Okay. Now, are you able to get to a safe location? Are you able to go up to your car now that he's not in your car? Yeah. Okay. You digging in the pocket?
And Your Honor, I'm gonna pause it at 5:29. And I'm gonna skip ahead to 5:56.
Hey, where are you at right now? Okay. Is your garage door open? Okay. It's the toilet is in the garage. So that is upstairs. Yes, what's your name? Tracy? Carlos Fisher. Yes. Okay, I'm gonna stay on the phone with you until they get there. It'll be coming up pretty soon. Right. If anything changes, you let me know immediately, right? Does anyone else in the home check you too? Any? Where is she at?
She's in the house now. You know, that happened to the one that.
In the house. Okay, how old is she? What is your brother's name then? That'd be right. Okay, the officers are right there. Are you able to open the garage door and talk to them? I'll make up your with the officers.
And Your Honor, he's looking. Laptop. Ms. Fisher, was that a clear and accurate representation of the 911 call you made that night?
Yes. Yes.
Thank you. Your Honor, I have no further questions.
Mr. Hadley, your witness.
Thank you, Your Honor.
Good afternoon.
Good afternoon.
Now, the 911 call that we just heard, that was the first time you told law enforcement or, let me just back up. The 911 call we just heard, that was your first telling of the events of October 22nd, 2024, correct? You hadn't talked to police prior to that?
On that day?
Yeah, that was your first time telling that story, correct?
Yes.
And we just listened to that phone call. It was approximately 9 minutes long, correct? We just heard it. All of us in here just heard the phone call, right?
Yes.
And you called 911 because you said you were scared and concerned, correct? Previously when you were testifying?
Yes.
Okay. And previously you testified that you were scared that Mr. Fisher was gonna strike you because he pulled his hand back and he was gonna hit you, right?
Yes.
Isn't it true that at no point during that 9 minute phone call did you make a single accusation against Mr. Fisher for raising his hand?
At that point, the most.
Yes or no? Did you, isn't it true? Isn't it true that during that 9 minute phone call, you were calling for help, at not one point did you ever accuse Mr. Fisher of raising his hand to you? Yes or no?
Yes.
Yes, you did say he raised his hand on that phone call we just listened to?
Not what I heard, and I said, you said, isn't it true? And I said, yes.
So you called 911 and you reported that he was calling you nasty names, correct?
Yes.
You told them, he said you had no sex appeal, that you were a dumpy ass, correct?
Yes.
Okay, and you made mention that he may have been reaching into his bathrobe, correct?
Yes.
Very good. Okay, so you thought about mentioning that, you thought about mentioning the insults. You described to 911 where the cars were all parked, correct?
Yes.
But you failed to mention the very allegation that we're here on trial for today, correct? Which was that he raised his hand and acted like he was gonna hit you. You never said that to 911 when you called for help, did you? Yes or no? Well, you just heard the video, or I'm sorry, the audio. It's true that you never said that during the call for help, correct?
According to what I heard, no.
Okay, now, very early on in that call, when you mentioned that he had threatened to light your ass up, 911 was concerned for you, weren't they?
Yes.
Right. They asked, could you get somewhere safe, didn't they?
Yes.
And you could have easily at that point gone somewhere safe, couldn't you? If you felt you were in danger. You could have left the house. Correct?
Yes.
Okay, but that's not what you responded to 911 with, is it?
I don't have to worry about. I didn't have to worry about.
No, in fact, what you said before you said that was, why should I have to go anywhere? Why don't you all come get him? Isn't that what you told 911 when they asked if you were safe?
Yes.
You remember speaking with Romulus Police Department when they arrived?
Yes.
Let me back up. Did you make any false statements to the 911 operator?
No.
Now, the 911 operator told you to go get in your car to leave the house if you could, correct?
Yes.
But that's not what you did you?
Yeah, I got in my car.
Your car that was inside of your garage, correct?
Yes.
Okay, so you didn't drive to the police station.
No.
You didn't even try to leave the house.
No.
You just sat in your car in the garage after Mr. Fisher went upstairs and go to his bedroom and go back to bed.
Yes.
Okay. Now, if I told you it was Officer Green and Corporal Paisley were the officers from Romulus PD who you first met with, would you agree with that, or do you remember their names at all? But you did speak with two police officers when they first arrived, correct? Okay. Did you make any false statements to the officers? Did you leave out any important details that they would need to know in their investigation?
No.
Well, isn't it true, however, that you spoke to the officers right there where the garage door went up, right, standing in your driveway for probably, what, at least 5 or 6 minutes explaining to them what was going on, correct?
Okay.
Isn't it true that you told the officers that Mr. Fisher said, "I'll light your ass up"? You told them that, didn't you?
Yes.
And you told him that he was wearing a bathrobe and maybe he was digging for a gun in his bathrobe, right?
Yes.
Isn't it also true that once again, you failed to tell those officers anything at that point in time about Mr. Fisher allegedly cocking his handgun?
I'm not sure.
Mrs. Fisher, isn't it true that the one and only time you ever made that accusation was once you were filling out your written statement?
Your Honor, I'm sorry, to interrupt. Can you approach?
Sure.
This is the, look where you're at. So, what's that?
I just. No.
Like, don't know if there was a speaking objection or if that was just an approach.
No, I don't think there's an objection. No.
So since we kind of took a little side break there, the question was, and then back up in time. So you're standing in your garage, the garage door opens up, two police officers walk up to you, okay? You remember that?
Yes, I do.
Okay. And you remember telling the police officers what happened when there was two of them standing there?
Yes.
Okay. Isn't it true during that conversation, you explaining what had happened, you never made an allegation at that time about Mr. Fisher raising his hand to you?
I told you, I'm not sure whether I told you about that part or not. My conversation was about the life-threatening event that had just happened to me. If he had hit me, I probably wouldn't have died. But if he had shot me, I would have died.
Well, I'm glad you brought that up, because the officers, in fact, asked you, did you ever see a gun? And you said, no, I never saw a gun, correct?
I did.
911 asked you, did you ever see a gun? You said, no, I didn't, correct?
That's right.
Mr. Fisher was wearing a gray bathrobe loosely tied at the front, correct?
Yes.
Okay. So, did you believe that Mr. Fisher was carrying a handgun in his bathroom?
Yes.
You never said that to police, though, did you?
Yes, I did.
You said he had a gun on him?
Yes.
Your testimony here in court today, under oath, is you told police officers that he had a gun?
Yes.
Are you sure you didn't have another conversation with police saying, I don't even know if he has guns? Isn't it in fact true that's what you told police?
No, because Mr. Fisher is obsessed with guns lately.
I'm gonna, that wasn't the question, man.
I would never have said, I don't know if he has weapons. He has well.
Ma'am, I'm going to stop. Ma'am, I'm going to stop you. So do you remember speaking with police, correct? And you're aware that the police were wearing body worn camera that night, correct?
Okay.
Right? Isn't it true? Bear with me. That involves, I'm gonna ask one more time. Isn't it true that when you were asked, does he have a gun, your answer was, I don't know?
I could not imagine saying that.
So does your answer is, I can't imagine saying it, or you're telling, I just need to clarify.
You know, I would never have said, I don't know. I have had to take many of his weapons to the Romulus Police
I'm gonna
Department.
stop you there, man. That wasn't the question, and that's not what we're talking about. We're talking about October 22nd, 2024 right now, okay?
Mhm.
And about what you said to police. Okay?
Yes.
And we just listened to the 911 call. Let's just back up to there. Mrs. Fisher, you just listened to the 911 audio. Everyone here did, correct?
So,
We can play it again if we like. Isn't it true that about 3 minutes into that audio, or a minute and a half into that audio, the 911 operator actually asked you, "Do you see a gun?" You said, "No." You said that, though,
I
correct?
said no.
Did say no. Okay. And Mrs. Fisher, you know that 911 instructed you to get out of the house or to go to safety, and you said, "No, I don't need to leave, he should leave," correct? We covered that.
Yes.
Okay. Now, we do hear Mr. Fisher come back into the house on that audio we just listened to, didn't
Mhm.
he? Isn't it true at no point during that audio did he mention anything other than the vehicles that you guys were fighting about? At any point in that audio, did you hear him threaten?
No, I just heard him say nasty housekeeper and, all these insults. I heard that.
He was saying a lot of mean things to you that would hurt your feelings, no doubt, correct?
Yes.
No one likes to be called names. At least I don't. Do you like being called names by your husband? But not. I heard it wasn't a nice thing to say. But there was no threat, was there?
That was probably because my daughter was back in the house.
Okay, we'll talk about where your daughter was and wasn't in a minute. But there was no threat.
No.
Okay. In fact, Mr. Fisher, after the discussion about where the cars were parked, he went back upstairs, didn't he?
Yes.
Can you describe what Mr. Fisher's health was like at that point in time?
Here we go.
I'm sorry, what do you mean, here we go?
That's his game.
Ma'am, do you think ma'am, what was his health condition at that time? Where did he have to be that next morning?
Yeah, he did at the house.
Do you think kidney dialysis is a game? Why would you say that his illness is a game?
No, his illness is not a game. It's just the way he does it. Like, he'll, in front of certain crowds, he'll pull his cane out or some crutches. As soon as that crowd is no longer present, that cane is in the garage somewhere. I mean, it's a game
Okay,
for him.
okay. So do you think it's a game for him to go to dialysis at 4:30 that morning?
You know?
Was Mr. Fisher, at the time this happened, in frail physical health?
No.
No. He had no problem walking up and down stairs?
Your Honor, I would ask that we lay a foundation that complaining witness has personal knowledge, and I just want to be careful that we're not getting into complaining witness testifying to a medical diagnosis. She's not a medical doctor.
Fair enough.
Your Honor, there was no request for any medical diagnosis of this. They're a married couple. She's acknowledged that she knows he has dialysis. She stated she thinks that he uses it as a game. I think that's where we landed.
Go ahead.
Mrs. Fisher, you made statements to law enforcement that you and Mr. Fisher were no longer a couple.
Well, and
Did you?
we still live in the same home, but in many ways we're very different.
That's not what you said to police though, did you? You told them that you guys the relationship was done. correct, when you were speaking to the police officers that night? You told them, in fact, you guys sleep in separate bedrooms.
We sleep in separate bedrooms.
Didn't you tell him, in fact, that the officers, without being provoked, you threw out there that you thought 2.5 years ago, Mr. Fisher was out cheating around with other women, didn't you?
Yes, he was.
So you told police about Mr. Fisher's alleged infidelities and about the name calling, correct?
About the threat of my life.
That's what I'm asking about. You mentioned the name calling.
Okay, let's calm down, because I only want one person speaking at a time.
What was in there?
This is not the first time that he's read to shoot.
Okay, you've said that a couple of times. That's not what we're talking about.
Well, at some point, I have to believe if he's telling me that he's gonna shoot me. I mean,
Do you remember actually the officers asking you that? Actually, Officer Green asked you, do you believe he has the ability to shoot you? And you couldn't even say yes. In fact, you answered, well, I watch the news and it happens all the time. But you didn't tell him that you personally thought that Mr. Fisher was going to kill you, did you?
well,
Yes or no?
I was answering that question from my heart, but my mind, yes, he can shoot.
That's not what you told officers, though. That might be your answer today, but that's not what you told police when they asked you. In fact, Mrs. Fisher, common sense says if you thought he was going to shoot you, you wouldn't have stayed in the house, would you?
Yes,
So if you thought that your life was in danger, that someone was going to shoot you, you would have just stayed right there?
well, I did not have anywhere else to go.
That's not my question, ma'am. Ma'am, there's plenty of places to go besides being shot. Isn't it true that you did not make any attempt to leave a house and you just told us that you were in fear for your life?
I did go in the garage, and it was not going off.
We know. That's not my question. I said you made no attempts to leave.
Exactly.
Okay.
Right.
Now, we heard a lot of sound and audio on that 911 call. And you remember telling 911 he's coming back inside, referencing Mr. Fisher?
Yes.
Okay. And isn't it true, unprovoked? You just yelled out, "Don't you ever threaten to shoot me again." You remember hearing yourself yell that out?
Yes.
Isn't it true that for about the next 30 seconds, we don't hear you or Mr. Fisher on that audio at all, do we?
He was on his way up the stairs.
We don't hear you or him. We've heard background noise the whole time. Did you mute your phone?
No.
Okay. It's just coincidentally after you yell, "Don't ever threaten to shoot me again," he doesn't respond and just walked upstairs.
Yes.
And you didn't say another word?
No.
Okay.
I'm not gonna escalate the situation.
No. But isn't it true that you admitted to officers that you in fact did escalate the situation that night?
No.
No? You didn't tell officers that when you guys were having an argument and I quote, "You shut up or I'm gonna knock your head off." You don't remember telling police officers that you said that to Mr. Fisher in the kitchen?
Oh, yeah, when I said, "Oh, he a man."
No, ma'am. Isn't it true? Oh, hit him back. Were you hit?
He said that he was gonna whoop my head or something like that, and I told him, "No, you won't, cause I hit you back."
But you never told law enforcement that he was gonna whip your A, did you?
I'm sure I did.
You're sure you did.
Yeah.
And we'll get into what the officers and what was said and wasn't, but your testimony.
I'm sorry to interrupt, Your Honor. I just want to verify, was that, whoop your ass or shoot your ass? Or light your ass up?
Light your ass up that was also said.
I just wanted to verify if that's.
No problem. And Mrs. Fisher, when he said light your ass up, you previously said you thought he meant he was gonna shoot you, correct?
He did mean he was gonna shoot.
Okay, so light your ass up didn't mean anything about reaching his hand back to hit you. It's about shooting you is what
Those
you're.
are two separate things.
Right, that's what we're trying to clear up. Okay. Isn't it true that you fill out a victim statement, a handwritten victim statement? Okay. You left out in your victim statement the fact that you had also made verbal threats to Mr. Fisher, didn't you?
Let me see it.
Problem. You're gonna let the record reflect on the approach to witness. Your own victim impact statement. I don't know if it'll be refreshed on cross, but we're gonna give it a shot.
I'm sorry, Josh, is it the victim impact statement or the written statement she gave to the police?
It is titled Domestic Violence Incident Victim Statement. I can give opposing counsel a copy because I thought we might be good with this.
Okay, I just wanted to make sure the victim impact statement, I want to make sure.
Your Honor, would you like the copy as we go?
Sure.
The record reflect, handing a copy of the victim. That's my statement.
And I'm sorry, are we marking this for purposes of the record, because if it's just being used for.
Hasn't been laid yet, we'll see. Don't read from this document yet, Mrs. Fisher, just tell me what this is.
Violence incident, legal statement.
Okay, this is your statement, correct? Has it been altered or changed in any way? Do you have any reason to believe the police changed your statement?
You asked a question, I don't know.
I'm asking a follow-up question. Do you think the police changed your statement?
False for speculation.
Withdrawn. I'm gonna ask you again. Go ahead and read through the statement. Is this your statement?
Yes.
Isn't it true at the end of your statement, you said, right, well, I called the police to report both threats of violence against me, end quote. Those are your words, correct? Right on the statement. Is that what you said? Very last sentence.
Yes.
Isn't it true? You called 911. You in fact did not report any alleged cocking back of the fist as we covered earlier.
Yes.
Now, Mrs. Fisher, your daughter was there and she made a statement to police as well, correct?
Yes.
Okay. You weren't standing next to her when she made her statement,
No, I was not.
so you wouldn't have been impacted what she was gonna say to police. Okay? Do you think your daughter had any reason to lie?
No.
And you stated that your daughter was inside the kitchen area and that's how she was able to hear. I think as you stated, I'll light your ass up, correct? That's what you previously testified to, that your daughter. What'd you say? What'd your daughter hear?
She's coming in from the garage.
Okay, and you said that she didn't hear anything other than the statement, I'll light your ass up. That was your,
Objection, Your Honor, that calls for speculation.
that was the previous testimony, Your Honor, on direct.
Yeah, I don't think it caused speculation. The way I understood, you were asking her what she said.
Correct.
So maybe
Under oath.
restate the question.
You testified earlier today. And you stated that your daughter heard Mr. Fisher say, I'll light your ass up. You said that earlier, correct?
Yes.
You can remember what you just testified to a little bit ago, right? I'm not trying to jam you up. Remember what we talked about?
I don't know what she heard. The only way I know she heard that is because I heard her say, you were like, ooh.
You previously testified that she hadn't heard any of the other argument, correct? Today you testified.
Today I said that?
Yes, you said that the only thing that she walked in and all she had heard was the tail end of the argument.
That's all I think she heard.
Okay,
That's all she heard, so.
so that's you. So I just want to make sure you're changing a little bit now. You're saying that's what you think she heard.
I'm not changing anything.
Good.
I'm not.
You did previously testify that the only thing she heard when she walked in.
Okay, the only thing I think she heard was that. I'm not in her ears. I don't know what all she heard.
Okay.
And that's fair enough.
And where was she at when, in your mind, when this was said? Where do you believe your daughter was standing when she heard?
I don't know.
You have no idea where she was standing. Well, if I put these back together, Your Honor, can see it again. Well, go ahead and move to admit the victim statement as will be defense exhibit, I guess that's one. Yes, Your Honor.
No objection, it's 2 pages, correct?
It is.
That'll be admitted. What do we call it? Defense one?
So I want to jump back to that 911 call that we all listened to. The 911 call. Very beginning of the phone call. The officer or the dispatcher was concerned about your well-being, and he stated to you, did he actually hurt you? Do you remember hearing that?
I don't remember one.
Okay.
You talking about when I was on the phone?
Right when you called 911 and you stated, my husband, first you started with my husband and I were arguing.
Yes.
And then you went into the allegations that he said, I'll light your ass up and reach for a gun. Okay. We've established that there was no mention of raising a hand during that 9-minute phone call, no allegations about the punching or alleged acting as if he was gonna punch. You responded to 911 when they said, did he actually hurt you, with a question back? Do you remember that saying, did he hit me? That was your question, back to the operator, right?
Yeah, if you want me to answer it, play it again, because I can't remember that.
You want to cue it up and pull it in? While I'm doing that, Mrs. Fisher, isn't it true that at that next question from the 911 operator, he stated, the operator, did he hit you or do anything to you? You responded no. Do you remember that?
Yeah.
No problem. No more. Well, bear with me, nice. Heather, do I need to hit anything to get audio up?
I don't think so. I think audio will go. What do you think, Joe?
Well, Your Honor, when you said that nobody was to be less stressed with digital computer things than him, I almost jumped in his thing.
Do you want to use my computer, Josh?
I've got it right here. Let the record reflect. 911.
Okay, what's going on? Did he actually hurt you? Yeah, okay, you, or did anything to you?
Okay, so we just heard it. The operator first asked you, did he hit you?
No, nothing.
Okay.
That's all we really established, right?
Then the operator asked you, did he do anything to you? And Barbara said, no, correct? That's what we just heard.
And
Okay. Just a few more questions. Now, do you remember when you were speaking with the two officers, at one point, one of the officers pulled you with him to go do the statement, and the other officer went inside the house? You remember that, right? Okay. So you were with Corporal Paisley when you, let me just back up. I'm not sure who was the officer. Do you remember the officer that was helping you fill out the statement that we just admitted into evidence? Do you remember speaking with him?
I remember speaking with him on the third, I don't know what his name was.
Do you remember stating that you guys have been married for 20 years?
Yes.
You were stating, he's just real mad at me because 2.5 years ago, I caught him in a whole bunch of cheating mess. He's just mad that I'm not accepting that. You remember stating that?
Yes.
Do you remember continuing on with that, saying, we don't even talk to each other. I don't know, we aren't back together. I just can't afford to move.
Yes.
You told him again, if you could afford to move, you would have left. Correct? Prior to this night.
Possibly.
All right, no further questions for Ms. Lewis.
Ms. Mandernack, redirect.
Your Honor, I request permission to publish defendant exhibit 2.
That was a stipulation too?
This was already submitted by stipulation.
911 call or what is it?
Oh, no, this is defense exhibit 1. This is a copy of the complaining witness written statement.
So I believe the people admitted the 911, that would be exhibit A, and this would be defense exhibit 1.
Well, we're doing 1 and 2. So you want to publish his exhibit?
Yes.
Yeah, go ahead.
Computer plugged in? So do you? Yes, please. Okay, you should be able to see this on the little screen in front of you as well. This is a copy of what's been admitted as defense exhibit 1. What is this?
Violence incident with rape.
And I can hear what the paper. Your Honor, may I approach?
Yeah.
Ms. Fisher, I'm handing you you've already got a copy of it, but I'm handing you another copy of what's been admitted as defense exhibit 1. What is it I just handed you?
Violence incident with rape.
Okay, and who wrote out the statement?
I do.
Okay, is that your handwriting? Okay, and when did you give this statement?
Pardon?
When did you give this statement?
Right of this.
Okay. And in this statement, do you state that Mr. Fisher told you that he was gonna light your ass up?
Yes.
Okay, then you indicate in the statement that he also reached into his pocket like he had a gun,
Yes.
and you also state in the statement that he also raised this close to my face as if he was going to hit me.
Yeah.
But he stopped and said you were a coward and you were just going to call the police.
Yes.
Okay. Thank you. Your Honor, will you unplug it? And Ms. May I approach?
Yeah.
May I continue permission to approach?
Yeah, go ahead. Stop.
She got it.
I'm gonna take that one off from you too. Thank you. And Ms. Fisher, you spoke with police officers did you speak with police officers when they came to the scene? And were you truthful when you spoke with the police?
Yes. Yes.
Here's the foundation with there was multiple statements in.
So this is, Your Honor,
Go ahead.
I am going to admit, or I'm seeking to admit as People's Exhibit 2, via stipulation of a portion of the body, the audio portion of the body on camera, where complaining witness is speaking with, Paisley, who has responded to the scene. I intend to start it at 14:09.
And
I intend to stop it at 22:39.
Agreed?
Your Honor, without being able to, I'll,
If defense counsel would like to view it, I've got it.
I've made my objections as to what's inadmissible on this. I think we know what the third rail is not to touch. If the APA is stating that no, inadmissible evidence is gonna come through on this, I don't need to delay the process.
That's fine.
Clarifications for referencing.
Just starting.
So it's basic objection form, so as to not confuse and needlessly delay this, what I would ask is to be clarified when in the interview, when in the evening this interview occurred. Because we've established there's been a 911 call, there's been an interview with police, and now we're moving to another recitation of the events. So for the jury to be able to follow where we're at.
I think that's fair. I think that's fair. And I just want to clarify another thing. You were just going to do audio only. Okay. So is this the initial contact when both officers were speaking to Miss Fisher, or is this the later when the officers had split up?
I am not sure, Judge.
Okay.
Small night typing. There is no video, it is audio somewhere.
Yeah, looks like, so this would be when they separated, because it's not like seeing on the grades.
So it's within normalcy again. See, it's still.
All right. So this is the one-on-one interview with one officer and Miss Fisher. Okay.
This is the third, the witness's third statement of the incident.
Agreed, Miss Manonak?
I don't know if it's her third statement of the incident, Your Honor, but I can testify, but I will state that this is a separate statement. This statement was given after Officer Paisley had separated from Officer Brady.
Okay, clear enough.
We'll start at 14:09. This is gonna be audio only. Oh, and I have the publication. Oh, actually, Judge, I'm going to start at 13:40, if that's okay.
Same concern, Your Honor, just to not touch the third rail of a mistrial, as long as counsel says that we got nothing that's in the red, I have no objection.
Understood.
All right, I didn't have no issue with technology.
And, you know, even then, you didn't move the car, giving the key to the car or whatever, and you're ready to shoot you and make a gesture.
And I'm gonna stop at 14:53 real quick. Mr. What are we listening to?
The officer, he come over to the back of the car. You know, the back car and tell you what to say.
Oh. And, the officer references, he's telling you to write down what you had previously told him. Is that accurate?
Yes.
Okay.
And when I was in the kitchen, when we started, he came up to me like this and said, oh, no. Police.
Okay, and I'm stopping it again at 15:02. I'm just gonna replay that portion real quick. Starting at 14.
It will shoot you, basically, right there. I can call you this thing, right? Okay, and then right exactly what you said, you came home from work. You came home from work and, you know, he got mad because you didn't move the car back or give him the key to the car or whatever, and ready to shoot you with a gesture.
Understand what it's like. And when I was in the kitchen, when we started, he came up to me like this and said, oh, no. Police.
Okay, so, Ms. Fisher, I want to bring your attention to that last portion. You are telling the officer that, the defendant put his hand, and did you make a gesture when you told the officer that?
I don't think so.
Okay, if you don't remember, that's okay.
I don't sure.
Okay. That's okay. But you do tell the officer that the defendant put his hand.
Yes.
Okay. Starting again from 15:02.
Then I'll let me know.
And judge for the sake of brevity, I'll just skip ahead to 2052. I'll have an objection.
Headline. Going. This, so, the rank of this one is. Second.
Yes.
Okay.
Yeah. I'm having currently at 15:26.
No, fine, go ahead.
Starting again at 2052.
Since I was in for work, my husband got those chains outside to meet my car, but I did not put the keys fast enough, so he called me and we argued until he said, I don't light your ass up, as he reached in his pocket like he had a gun. He also raised his fist close to my face as if he was going to hit me, but he stopped and said, you are a coward and you just don't call the police. When he went outside to move my car, I called the police for both threats of violence against me.
All right, I'm gonna stop that at 2133.
So just a clarification, that was Ms. Fisher reading the statement back to the officer. Okay.
Ms. Fisher, was that you, reading the written statement that you just made back to the officer? Okay. And were you being honest in that written statement?
Yes.
Okay. Why did you not previously why didn't you tell 911 about the portion of the incident where a defendant raised his fist at you?
So much was happening so fast, and I felt like the most important information was that I was going to get shot. That was the most life-threatening to me. If he had, like I said before, if he had hit me, I could survive the hit. So I thought I was important, the most important details, and then out of nowhere, I remember he also threatened he was close, like he really was gonna punch me in my face.
Okay.
And once I remembered that, I was like, oh yeah, let me tell you this too.
Okay.
And he knows that's the truth.
All right, I'm gonna stop you right there.
Judge, can I just go ahead and ask the last part, Mr. Strickland, from the record?
Stricken.
Right, and, why didn't you leave the house?
First of all, my daughter was late, my daughter does not have anywhere else to go. And I do feel like, you know, why is he always, he is always calling me names around the house, threatening me and all this kind of stuff, and I'm always the one to leave.
Okay.
Why is it that he is just getting away with like antagonizing? Constant.
All right. Your Honor, I have no further questions.
Mr. Hadley, any recross?
Just one, for clarification, so just so everybody, the jury, myself, judge, prosecutor on the same page. Back to the question she just asked, you would agree the first and only time that you mentioned that Mr. Fisher allegedly pulled his hand back was at the very last statement you made to the officer, correct?
I don't know. I know I made a statement at that end, but I don't know if I said that before or not.
Okay, no further questions.
Ma'am, you can step down. Watch your step on my ramp.
Your Honor, I think the jury may be, they might be ready for a
Do you want a break? You ready to go into another witness?
question, you got a question?
Oh, you got a question for the witness? Oh, ma'am, don't leave yet.
Yes, sorry.
That's fine. Have a seat. I think Mr. Plesko's got, you got him. That's all right. Take your time. Let them see it first.
Judge, I'm gonna stand for a minute.
Yeah, that's fine. We got one more coming from Mr. Plesko.
Just straight, just straight. Position.
Yeah. Let's listen to the rest.
One of those had something on both sides of the page.
You know, how, obviously deferring to the court as to the jurors' questions, does the court plan on doing the inquiry?
Oh, I don't care. You guys seem to be working well together. You think all those questions can be asked or at least tweaked and asked?
Your Honor,
Bring them up.
Absolutely.
We're gonna give you a break because there's a lot to go through on all those. So Joe's gonna take you back into the deliberation room. While we hash out all the questions. Yeah, but-
Talk about the case at all back there, right?
Correct.
It's done. Let's see it. All rise for the jury.
You're still under oath and you're still warned about my incline ramp. Don't trip up here. Go ahead and make yourself comfortable in that chair again. So folks, the attorneys and I went over all the questions submitted. Some of the questions are going to be asked of Ms. Fisher as they were written. Some have been tweaked. Some will not be read at all. And I'll explain, well, there's two reasons. Some of the questions are getting into things that are not relevant. And I'll explain that when the case is all over and I get you back in the jury room, we're talking about it. And there were, I'd say a number, probably 3 or 4 questions that we agreed the question had already been asked and it had been answered. And then that we go back to when you're in the deliberation room. For example, if one of you have a question that didn't get asked on, you submit it on paper and you think it might be because it was already asked, then you can say, so I had a question, blah, blah, blah. And then your fellow jurors can say, oh yeah, but she answered that one because, you know, that's why we put 6 of you in the room together, right? Because one of you might have missed something while you were making a note or focused on something else. You use your collective memory. That's what deliberation is, right? You work together. All right. So Ms. Fisher, the question is, are you and Mr. Fisher still married and or still living together?
Ms. Fisher and myself are still married. We no longer live together.
Thank you. At any time during this incident, did you approach Mr. Fisher in an aggressive manner?
No.
At that time, did Mr. Fisher own his own car?
Yes.
And that night, did you think he was going to take your car somewhere?
No.
Okay. In the past, had he ever put your car into the garage?
Yes.
In the past, had you and Mr. Fisher ever discussed your parking in the driveway or the garage?
Mr. Fisher and I were, in a ongoing, like, we dated properly. We belonged to their car. We were together. Problem, the problem is that. But the problem, we ever started to a car, the car was really paid like. The car became an issue, it did.
But I think the question was more, was the location where you parked the car ever an issue in the past? Okay. And I think that takes care of it. So I think it's only fair, any follow-up questions necessary from either defense or prosecution based on the juror questions.
No, Your Honor.
I don't think we have that.
Okay, all right. Now you're done. Watch your step. You can step out. And I think, Ms. Mananak, based on our earlier conversations, you're going to call Carlos next.
Call Carlos Fisher.
If you don't mind, ma'am, when you go out, would you just send your daughter in? Thank you. And folks, from our discussions, not ours, but ours, Carlos is going to be much shorter testimony than Stacy. So then at that point, Mr. Hadley will probably have a better idea where he's at as far as witnesses, and then I'll let you know what we think we're at, and then you can decide if you want to take a break at that time. All right?
Write down questions for Carlos.
Oh, sorry.
Yes. And you want to use those? Or just use the notepads? Yeah, you
Okay.
just rip out a page out of that steno pad and jot down whatever you want. You are a group of overachievers, though, because I've never had so many people at the same time want to ask questions. Ms. Fisher, up front, please. All the way up front. You're going to come up here on this incline ramp, so be careful you don't trip. All the way up here. You're going to sit in that chair eventually. All right. Raise your right hand for me. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Have a seat right there. When you're ready, Ms. Mananak.
Good afternoon, Ms. Fisher. I'm going to take you back to the night of October 22nd, 2024. Where were you at that time?
I was at home,
Okay, where is home?
612 Swan Drive, Waterloo, Michigan.
Okay, and who else was there with you?
My father.
Your father? Do you see your father in court today?
Yeah.
Could you please tell us his name?
Carlos Fisher.
Okay, could you please point to him and tell us something that he's wearing?
Black shirt.
Noted.
And Ms. Fisher, was anyone else in the home with you that night?
No.
Okay. Who is living in the home?
My father and
Okay, who's your mother?
Stacy.
Okay. And on October 22nd, 2024, did your mother come home at some point that night?
Yes.
Okay, where were you when your mother came home?
I was in my room.
Okay. And what happened? Did you overhear anything when you were in your room?
Well, what happened was
both of our cars, mine and my father's car was in the way. And I came downstairs to move my car. And when I moved my car out of the way, she was already parked in front of his. So I circled back around. And then I saw her walk away from him and him walk behind her into the garage into the home. And then I pulled in the driveway.
Oh, sorry, go ahead.
I pulled in the driveway. And then I went in the garage and, followed behind them. And then I heard yelling, stuff like that.
Okay, who did you hear the yell coming from?
Both parents.
Okay. Do you remember what your mother said?
No, I couldn't hear anything until I got to the door.
Okay, what happened when you got?
I heard my father say, I want your ambulance.
Okay. Did you hear your mother say anything? Did you see any of the incident?
Well,
Okay. Where were your mother and father when you came downstairs to the car?
my mom was still outside and my dad, I couldn't find my dad.
Okay. Your Honor, I have no further questions.
Mr. Hadley.
This will be quick, I promise, Carlos. Thank you for being patient out there today. You remember speaking with police the night that all of this happened?
Yes,
Okay. And you were truthful with police that night, correct?
yes.
Okay. Do you remember what you said to police when they were asking you for your witness statement?
When I said to the police, I said, everything I just said now, and I did say that I like you.
Do you remember filling out a written witness statement? Do you remember what you put on your written witness statement?
Not every.
Let the record reflect the showing opposing counsel. Witnesses on witness statement. Permission to approach?
Yeah.
Can you identify this document?
Yes.
Okay, what are we looking at?
What I would.
Okay, and is this your statement? Okay, has it been changed or modified? And what did you tell police?
I told him, I heard my father say, I want your assets to my mom.
And then there's a big X below it. You didn't hear anything else. Is that what your testimony is? Okay. So you didn't hear anything before. You didn't hear anything after. Okay. Isn't it true that when you were speaking with the officer, you stated, and I quote, "That's all I heard because I was standing outside," end quote.
Yes, I'm standing outside the door that's connected to the house.
Okay, fine. I have no further questions for this witness, Your Honor.
Any,
We'll go ahead and admit what we now marked defense exhibits.
I have no objection. This
Three.
defense.
she'll figure it out. Okay, that'll be admitted.
And we motion to have this published to the jury as well.
Any redirect?
No turn.
You can step down. Thank you. Watch your step. Oh, I keep forgetting.
That the only question?
Anybody else? Don't go anywhere yet. We might have another question or two. You guys okay with the way they're written?
So don't worry about my cops.
Want to pull up?
Good questions again? Sometimes we know our story and forget the next. Oh.
Okay. Miss Fisher, is Carlos your bio dad?
Yes.
All right. And how did you know your mother had arrived home?
saw her through the front window. My room is right in front of the house.
Okay. Had she called you that night and asked you to move your car?
See her.
Okay. Did your father ask you to move your car?
I don't know.
If you know, did your father see you going outside?
I
And at what point did you know that someone had called the police?
I knew my mom called the police after the argument, when he went upstairs, after he rearranged all the cars and everything. After the argument, she had the police on.
Okay. All right. I think that covers it. Either one of you got follow-up questions? Now you can step down. Watch your step. Thank you. Can you two approach real quick?
Yes.
We'll let her get out of here first, so we're not.
But once we say quick, and then
I know, everyone.
You're all set. Thank you.
big discussion.
Like this.
Well, ask him. And I will so you them.
Yeah, it may still be a good time to break anyways, well,
Let's just deal with one thing at a time. No cough drop.
Your Honor, I think at this point in time,
2 or 3.
may change, but right now, we're gonna go to.
Okay. All right. So the prosecutor's done presenting witnesses at this point. Mr. Hadley wants to put both the officers on for just like literally a couple questions. So that should move pretty quickly. Are you okay to keep working? Okay. Do you care which one first? Which officer?
No, or to,
Keep working? Yes.
well, I believe I know the answer. The court's ruling on one of my motions.
Oh, you want to make one? Just to make it? Go ahead.
You know, we'll go on at this point in time. It needs to be done outside the presence of the jury, so I don't want.
All right. I don't care which.
No, let's keep
Any-
the show rolling. These folks are, everyone's, I think, the story's moving, everything else is going on.
Anybody with a rhyme nose badge?
Again, Stacy Fisher and Carlos Fisher be excused.
I have no intent on that.
Sure. Sure.
Here are the people.
I knew that. Good afternoon, Corporal. Come on up. Swear, affirm, tell the truth, the whole truth, nothing but truth. Watch your step on my ramp. I'll settle in. When you're ready, Mr. Hadley.
Good afternoon, officer. Good afternoon. Sorry, horrible. My sincere apologies. Vern, I'm gonna try to keep this quick, just kind of roll through a few questions for us. Did you have a chance, to refresh your memory, look over the reports, kind of video from this case?
Reports, yes.
Okay. Do you feel you're pretty well caught up to speed and able to answer my questions about what happened on October 22nd?
I guess it depends on what kind of questions you have.
That's a good answer. Let's just kind of jump right in. Were you and Officer Green on patrol together that night
Yes.
when the call came in? Okay. What, if anything, do you remember about the 911 operator giving you guys the response? Or why don't you tell me, what's it called when 911 calls you to respond? Is that
It's just a call for service, dispatch give us a call for service. To a
And-
location.
fine, just jump on me. What, if anything, do you recall about the call that came in about the Fisher household that night?
If I remember correctly, it was a domestic violence call with a possible gun involved or something like that.
And did you and your partner have a discussion about the allegations in the car on the way over to the scene?
Yes.
Okay. Do you recall discussing anything about whether there was physical violence alleged in this one?
I don't recall everything that we talked about. It was just, kind of like throwing out, what could possibly could happen and how we're going to deal with it basically.
It's fair answer. When the 911 call came in, there was no allegations about Mr. Fisher raising his hands to Mrs. Fisher on the 911 call, was there?
Don't recall. I don't recall that. I just remember some about anger and possibly involved.
And I'm not gonna march through all the step-by-step trainings that you've gone through. Why don't you just tell us in your own words, what type of training did you go through to become a police officer? Briefly, I know there's a lot.
Police Academy, numerous training years.
And was one of the things that you were trained in, taking case reports or police reports?
Yes, sir.
Okay. And why are police reports and case reports so important in a criminal investigation?
So we can refer back to what happened.
And the ninth question, October 22nd, 2024, were you equipped with body worn cam that recorded the incident?
Yes.
Any reason to think that the recordings have been tampered or altered with in any way?
Oh.
Now, when you and Officer Green arrived at the Fisher home, do you remember what you did after you parked?
Basically parked, got out of the vehicle, approached the house, and I believe we were met by the victim. She came out of the garage or something.
And at some point, did you and Officer Green split apart? Did you take Mrs. Fisher with you to go complete a victim statement?
I did, yes.
And do you remember kind of guiding Mrs. Fisher through what needed to be completed on that form?
Yes.
And I'm gonna go ahead and put words in your mouth and go ahead and quote it. Do you recall stating to her after she had repeated her story to you? Do you remember recalling? So that's basically it. As she was writing out her story,
Could have said that.
did you recall at that point in time her adding in this new allegation for the first time about Mr. Fisher allegedly cocking his handbag?
Yes.
Okay. And you don't recall her ever bringing that up to you prior when you were interviewing her?
I don't recall, no.
Would it be helpful if we went through the video tonight or today? I guess I should say.
If you want to, sure.
Are you going for video or audio only?
Did you have a chance to look? Good question. Did you have a chance to look at your body cam footage from that night?
No.
Okay. Would it surprise you if I told you that we can hear you, but there's a blurry or blocked image.
And you know what it might have been? Because in the wintertime, I wear my jacket, body cam is right here. And I wear my jacket over this. That's probably what it was.
Cause we can hear you just fine, so that makes sense.
So audio only.
This will be, yes, I mean, there's video, but for our purposes, audio is the only thing we need to be concerned with.
Good, because it's easier to do.
And Heather, is this gonna pop up or do I need to do anything?
You did it, wait, is it the play?
No? So another button needs to happen.
Not for audio.
Not for audio, for video, yes.
Oh, I don't have just audio. That's, I think, what this is video. It's video with no clip, with no workable
Okay.
image. Sorry. So we're all saying the same thing, just differently. Video, I just can't see.
I'm sorry, Mr. Young, is this, Officer Paisley's writing?
This is, so it's been provided by the People's Discovery 10_22_2024_2455_Byron_Paisley.
Thank you very much, Mr. Randall.
It's showing on this screen, but for some reason not on. Is it showing on anything on your guys' screen? You get the, oh, perfect,
Here we
okay.
go. Now Corporal Paisley, you heard me rattle off all those numbers. Do you recognize those as your body worn cam?
I'm sorry.
Those numbers I rattled off that, and then in your name, do you recognize that?
Oh, yes.
It's on your screen right there, Beasley, just so that you know that's where it's gonna come out.
In audio, we'll start up in just a second here.
Recording, consent recording.
Your Honor, this is a 33-minute video that's already been stipulated to. The first 8 minutes of this are the officers traveling to the Fisher home. I'm gonna go ahead and jump forward to the relevant.
Thank you.
That's what's going on.
So Corporal, do you recognize that voice?
Yes, my voice.
Okay.
Oh, this is your mom. Your mom. Yeah. Yeah, it's fine.
I'm trying to get out my friends. And I think. He comes in the house calling me a bunch of names, he's bad, don't be, and you know, all of this stuff. And I'm telling him, don't say another word to me, don't say something else. Get out of my face.
So far, you would agree with me that there's been no mention of any alleged cocking with fist back to this point?
Yes, sir.
Right? Your Honor, stopping is 9:27. I want to jump forward. 30 seconds.
All the time, Marshall, trying to get out of here.
Were you able to hear Mrs. Fisher tell you that she's been trying to move but doesn't have money?
Yes.
Do you remember Mrs. Fisher also telling you that night about other marital problems that they were having, her husband calling her names, cheating on her?
Yes.
Okay, or allegedly cheating on her? Okay. You responded to lots of calls in your years as a police officer, correct?
Yes.
Do you think that it's rational for a person who is in fear for their life to voluntarily stay in a home?
Objection, Your Honor.
What's the objection?
The objection is that he's effectively asking the witness to testify as an expert witness in domestic violence, which he hasn't been qualified as.
Response.
Your Honor, I'm not asking him to opine if this person acted reasonably. I'm asking him, pulling on his years of experience as a law enforcement, I can ask it in maybe a little more appropriate way. Let me,
Rephrase it.
I'll withdraw the question and rephrase.
Go ahead.
In the years that you've responded to threats of violence, is it common for somebody who's been threatened with their life to voluntarily stay on the scene?
Objection, Your Honor. Relevance.
I'd say it was highly relevant, but
You want to respond to the relevance?
oh, absolutely, Your Honor. I mean, this is directly relevant to whether or not testimony that the jury has already previously heard today, again, would be into that scope of reasonably objective. This officer has responded to hundreds, perhaps thousands of calls. We're not asking him to opine what happened that night, just pull from his years of experience as an officer, if that seems reasonable.
Your Honor, would you like me to respond?
Sure.
Regarding the relevance, defense counsel is asking about other incidents of domestic violence that do not include this complaining witness or this defendant.
I don't remember domestic violence being in the question.
That is correct, Your Honor. It's just about someone whose life has been threatened in general. It could be a bank robbery, it could be a hostage situation.
I think it's relevant. I don't know what it's worth, but I think it's relevant, so I'll allow it.
Your Honor, my second objection is I would sustain my previous, or I would renew my previous objection that defense counsel is effectively asking the witness to testify as an expert witness, if not on domestic violence specifically, witnesses' reactions to traumatic experiences, which the witness has not been qualified as an expert in.
I think the question was in your experience, and he's certainly qualified to answer questions about his experience as an officer.
Thank you, Your Honor.
Welcome. If you still remember the question, Corporal. Go ahead.
It's a lot. The good news is this time I did actually, but it's the trouble is my like, oh boy, what did I just ask? What we're trying to gather is in your years of law enforcement, when people have claimed to police that their life was in danger, do you find it a common occurrence that they remain at the scene and having their life threatened?
No, they usually try to leave, get away from the situation. That's why we help them out by, locking up the person that we, if it's some kind of crime that's been committed. So they have a chance to do whatever they need to do.
Now, at some point, you did take a written victim statement from Mrs. Fisher, though. Is that correct?
Yes.
And do you recall what she stated in that? Your Honor, I think mine may be stuck in a stack. Is this Stacy Fisher?
I think I got.
Let the record reflect when approaching the exhibit. May I approach the witness, Your Honor?
Sure.
Let the record reflect approaching the witness with what's been marked Defense Exhibit 1. You don't need to read this. Just can you identify what this document is?
Domestic violence victim statement sheet.
Okay. And is this the sheet that you assisted Mrs. Fisher in completing?
Yes.
Okay. And do you recall kind of leading her, or I guess let me rephrase, do you recall repeating the story that she previously told you as you guys were kind of completing this
I
statement?
was kind of going over it, yes.
Okay, you're kind of directing her which of the boxes that had to be checked and which ones didn't, okay.
Yes.
And we can go back to the entirety of the 33-minute video. I'm just asking you the best of your recollection. Was this the first time that you'd heard anything about an alleged hand being pulled?
Asked and answered.
I don't know, we got it in.
That was the direct question you asked him before you played the audio, and that's the absolute exact answer. So you've established that he didn't remember it. You played the video, they got it in.
Go. You also interviewed Carlos Fisher that day, correct, sir?
Yes.
And that was a really quick interview compared to Mrs. Fisher, right?
Yes, sir.
And you recall getting her victim statement?
I don't know if I got a victim statement for her or not. Not sure.
The record reflects approaching the witness with what's been marked Defense Exhibit 2.
Oh, wow, okay, I did it. Yes.
All right. It is, as you got the statement from Carlos Fisher, she had nothing additional or anything extra to add, correct?
No, sir.
If she had, you would have told her to put it on the report, correct?
Yes.
I have no further questions, please.
Ms. Mananek,
No questions, Your Honor.
Corporal, you can step down. Thank you. We want officer, oh, I'm sorry. I should just be asking Ms. Burnett.
Hi, I'm here.
You want to take that feet off?
Yeah, let her have her notepad back.
Your Honor, I kicked myself. It was actually on my list to ask.
All right, so let counsel look at it, because it might not be on her list.
This. No.
Let's,
Come on up.
Another prosecution case.
All right. Corporal, was Mr. Fisher arrested that night?
Yes.
And how was Mrs. Fisher acting that night? Body language, emotional state, however you want to explain it.
That's it.
Any follow-up questions?
no, Your Honor.
Well, you described her language as upset. Would you say she seemed afraid?
Yes.
Do you recall her saying to you, she had told her husband, I'm gonna knock your head off?
I don't,
Your Honor,
What's wrong?
Okay,
What's wrong? No further
Thank you.
questions.
Corporal, now you can get back to whatever you'd rather be doing.
Your Honor, returning the court's exhibits.
Next.
Let's do that. That'll be very.
Corporal, would you send Officer Green in
yes,
on your way out? Thank you very much. Stay safe.
thank you, sir.
Thanks, Tim. Officer, come on up. Raise your right hand. Swear affirm, tell the truth, the whole truth, nothing but the truth today. Come on up, watch your step on the ramp. Settle in the chair. Are you ready, Mr. Hadley?
You know, how are you?
All right, so,
Good, good. We can see the record.
Yes, Officer Tom Green.
Okay. And how long have you been employed with the Romulus Police Department?
It'll be 3 years in the minute.
So it's fair to say you've been on numerous calls before the incident in question here today? Right. Not your first rodeo?
No, sir.
All right. Do you remember speaking with Mrs. Fisher when you and your partner arrived on the scene that night?
I do vaguely, yes.
Do you remember engaging with Mr. Fisher, my client, on that date and time?
Yes.
When was the first time you saw Mr. Fisher that night?
When we arrived for the call, that was the first time I ever seen it.
Okay, and when you arrived for the call, you walked into the home, correct?
I believe so.
Okay. Do you recall calling up to the stairs for Mr. Fisher to come down from his bedroom? It's not a trick question. If you don't remember, you don't remember.
I can't recall. I don't know.
Okay. Would it be helpful if I showed you your body worn cam video from that day real quickly?
Sure.
This does have video, Your Honor. Let the record reflect. This has been the previously stipulated exhibit. This is Officer Green's body worn video.
and just for the record, this says, defense exhibit 3.
This will be proposed well, I guess it's not proposed yet, so it's stipulated. Defense exhibit 3, Your Honor.
Thank you.
It's been published to the jury.
Should be on your monitor.
Do I have the monitor? Everyone's got it on their monitor?
Yep.
All right. All right, do you recognize what we're looking at here by the name number on the screen? Are you able to identify the video that we're looking at, sir?
Yes.
Okay, what are we looking at?
I was looking at the inside of the vehicle with the dash, instrument cluster, here's the, right hand steering wheel.
Okay, so this is your body worn cam?
I believe so, yes.
All right, it's from the night incident, or the night of the alleged incident, correct?
Yes.
All right. Do you? Let's go ahead and move to.
I'm sorry, what timestamp are we at? I
I'm
can't
gonna
see.
get to it. I'm just trying to get to the right relevant
Oh,
spot.
they just, I can see it very far.
I know. Just one moment. All right. So I'm at the timestamp. It's 5 minutes and 50 seconds. Do you recognize where you're at there? Where we are all at?
Yes.
Can you describe what we're looking at here?
Yeah, so looking at the stairwell of the inside of Mr. Fisher's home.
Okay. Is that your voice, officer?
Yes.
Now, is this the first time you'd seen Mr. Fisher that night?
Yes.
How would you describe his physical well-being as you saw him coming towards you?
Of course, more fragile than most. At this moment, it looked like it could be possibly sick as far as like under the weather or something like that. What does it look like?
Did it look like he needed assistance using that railing to even make his way down the stairs?
As far as assistance, I would say no, just making his way down fairly.
Just frail, just kind of weaker. Okay. Now, I gotta ask, you said you've responded to lots of calls before where there's, have you responded to other calls where there's been allegations of, threats with guns?
Yeah.
Okay. And when the suspect who's made the threat with a gun appears, is it common to tell the suspect to put his hands up in the air?
Actually, it's common for us to say that we want to see your hands up, their hands are in their pockets or something, we want to see.
Okay. It's for officer safety.
We say very wonderful.
It's true, nobody yelled at Mr. Fisher as he's making his way down the stairs that night, were they?
No.
In fact, wasn't most of the concern about Mr. Fisher keeping the front of the rope tied up and not giving anybody extra show?
Possibly on the low.
Right, come on. First thing first, you need to hold your own tight, pull the string tight, which you don't open. Pull it tight, so you don't open
We can agree, nobody's asked him to hands in the air, put him against the wall for frisk, nothing along those lines, right? Do you remember having a conversation with Mr. Fisher after you arrested him about strike that? Did you think Mr. Fisher was a threat to you
At this moment,
at any moment that night?
at any moment that night, no. After we were able to deem that he didn't have any weapons on, and he was clear of anything that could have harmed us, wouldn't be deemed a threat.
You did find a weapon that night, though, in the house that was Mr. Fisher's when you searched his bedroom, didn't you?
Yes.
Okay. And where was that? Do you recall?
I believe it was in a drawer of a dresser or some sort.
Let the record reflect, I'm skipping ahead in this video, Your Honor, to what's now marked roughly 2641. Actually, we're running back to 2620. Officer, is this you searching Mr. Fisher's room?
Yes.
And you're actually up there helping him retrieve his medicine as well, correct?
Yes.
And do you recall why he needed his medicine that day and time?
I believe Mr. Fisher said he was on dialysis or something like that.
Would you say that was consistent with him asking you to be careful when you guys were cuffing him because of his cord on his arm?
Yes.
Now, we're gonna see this gun in a moment, but agree that this gun looks like it's been wrapped up, kind of slipped away from you, correct?
it.
I'm gonna stop it there. Did you observe Mr. Fisher? He was wearing a gray robe, right?
Yes.
No evidence that there was a firearm on him as he was walking down anything. I guess that's my question. Was there any evidence they had a firearm on him as he was walking towards you?
As he was walking towards us.
Do you remember having a discussion with your partner on the way to the scene that night about reasonable apprehension?
I don't remember the conversation per se, but we always have conversations when it comes down to one different runs as far as what we could turn out to be.
Okay, as an arresting officer, if someone is alleging that they have been assaulted without a battery, are you familiar with what that would mean?
Assaulted without a battery,
Mhm.
assaulted without some type of physical force.
Okay. Sorry for the is that right? Yes, my fault. What would, we're talking here, what is a reasonable apprehension?
Judge, I think we're getting into a question of law.
Sounds like it. So what's your objection?
You know.
Hold on.
I do think I'm trying to,
Okay,
I'm
that's
trying
fine.
to speed this process.
That's fine.
My head too far.
Move on.
The only evidence that you had that night of an assault by Mr. Fisher was the complainant's statement that was corroborated in part by her daughter, correct?
Yes,
That was it.
from what I recall.
No further questions for this witness, Your Honor.
Thank you, Ms. Mandernack.
Thank you, Judge. Good afternoon, officer. And Judge, I'm just going to. Officer, you testified earlier, and the video indicates that you did not search Mr. Fisher when he was coming down the stairs, correct?
We did not search it.
Okay. Did you search him at any point that night?
Yes, after we deemed that we're gonna put her in.
Okay. Your Honor, I have no further questions.
One moment briefly, Your Honor.
Ms. Burnett? Questions?
I am sorry. Actually, number one.
Okay, all right. I'm just gonna send Joe over. That's all right.
If it's the same question that you didn't.
That's all right. Ask it. Ask it. It might be appropriate in this situation. The attorneys and I will look at it. Anybody else have any questions for this officer? Mr. Orban, you thinking about it? Okay.
Yeah.
That's the same.
Did we approach? Oh, I didn't see you were in the corner, Judge.
I said, get over here.
Yeah.
All right, Officer Green, how would you describe Mr. Fisher's attitude or demeanor that evening?
That evening, I would say that his demeanor, attitude, initially was calm, collected. He had his concern as far as, what we were there for necessarily, which is understandable. But he never really gave us an issue.
Okay. Any follow-up? Okay.
No, I have no further questions for this witness. Thank you for your time, sir.
Officer Green, you are released.
Yes.
Thank you. Be safe. Watch your step on the ramp. All right, and we're in agreement, no further witnesses to be presented today?
My client's been fully advised of his right to take the stand and his right to not take the stand. Based in light of what's been stated today and where we're at today, it's Mr. Fisher's decision, but he will not be testifying.
Okay, all right, thank you. Give me just a minute, folks. Updated. All right, so folks, here's where we're at. You're done hearing any testimony. The next thing you're going to hear is closing arguments. Then I'm going to give you final instructions. We'll update the tablets and send you back in to deliberate. I'm not going to time you, but I'm going to say closing arguments shouldn't be more than 15, 20 minutes.
Less, I think that the
Okay.
jury knows.
All right. So Heather's gotten real good at the updates. So what we need to do is the attorneys and I need to hash out what testimony came in. Based on what evidence you heard, certain instructions are appropriate or not appropriate. So the three of us will do that. I'm thinking it's going to be probably a half hour tops, and we'll get you back in here for closing arguments, and I'll roll right into giving you final instructions. Are you okay with just taking a short break while we hash out the final instructions? Or do you want to actually break for lunch and come back in an hour? Break for lunch? Okay. So it's 2:00 now. Can we be back to work at 3? That's not pushing it. That's plenty of time. Is it too much time? Because I don't want to waste any of your time. 3:00? Go away.
Awesome, and tell me, on the South fired up. You guys have.
Yeah. We'll take you. Yeah, this stuff is fine, but Joe will take you back in there to get whatever personal property you want. You can leave stuff back there too if you want. Right.
On that one.
Yeah. Because I want to know how much time they need. And then that takes the question.
Thank you.
Hey, Josh,
Yes, sir.
he doesn't have to stick around either if he doesn't want to. If Mr. Fisher wants to take off and come back. All right, welcome back. Back on the record. You can have a seat. And we're ready for closing arguments.
Good afternoon, ladies and gentlemen. I want to thank you again for listening carefully. I want to thank you for all your questions and keeping an open mind. So as I stated earlier, we are here today because on October 2nd, for this man, Carlos Fisher, assaulted his wife, Fisher, by holding his fist, putting his fist up as if he was going to punch her while he was standing next to her and extending his fist forward. And he also told Ms. Fisher that he was going to light her ass up. You heard testimony from Ms. Fisher that this happened at 6112 Swan Lake in Romulus, Michigan, in the county of Wayne. You heard testimony from Ms. Fisher you heard testimony from Stacy Fisher and Carlos Fisher that the parties were married at the time of the incident. You also heard testimony, you heard a lot of testimony from complaining witness in this case, Ms. Stacy Fisher. You heard her testify that, as she stated, defendant was right next to her when he drew his fist back and acted like he was going to punch her. She testified that she believed that he was going to hit her or physically harm her when he pulled his fist back. And I am going to, the judge is going to give you a whole bunch of jury instructions. I'm not going to read them to you, because the judge is going to read them to you. I do want to highlight one from the witness credibility jury instruction. And it states, you do not have to accept or reject everything the witness said. You are free to believe all, none, or part of someone's testimony. And when considering witness credibility, there are many factors, but all in all, one of the factors is all in all, how reasonable is the witness's testimony when you think about all the other evidence in the case. So in this case, Ms. Stacy Fisher, when she originally called 911, she told the 911 operator that defendant had threatened to light her ass up, and she told police that he had reached for his pocket and that he had a gun. She testified that she did not tell 911 that the defendant had pulled his fist back like he was going to punch her, because she was more focused on the gun. She was more focused on the more lethal threat in this case. She testified that she did not leave. She told the 911 operator why should she have to leave. We heard testimony from her that part of the reason she didn't leave is she had nowhere to go. And during one year, I know we talked about the various reasons that a victim may not leave a situation right away, or why, we might stay in a situation why someone might stay in a situation that's dangerous. You heard testimony from Carlos Fisher, the part defendant and Stacy Fisher's daughter, who overheard the defendant state that he was going to light Ms. Fisher's ass up. And you also saw Stacy Fisher and Carlos Fisher you saw the written statements that were admitted as defense exhibit 1 and 2. In complaining witnesses, or in Stacy Fisher's written statement, she does again state that defendant threatened to light her ass up and reach towards his pocket like he had a gun and pulled his fist back. So beyond the reason, the judge is going to tell you more about what exactly the legal definition of reasonable doubt is, but that's why we have you guys here to decide this. In short, a reasonable doubt is a fair, honest doubt or an evidence or lack of evidence. It is not merely an imaginary or possible doubt. And the thing I want to emphasize is beyond a reasonable doubt does not mean you all doubt, or beyond all doubt. I don't have to prove where someone normally parks their car or who owned a certain car. I just have to prove that on October 22nd, 2024, at that location in Romulus, defendant pulled his fist back as if he was going to punch Miss Fisher. I have to prove that Miss Fisher reasonably believed that she was about to punch. I have to prove that the defendant's action of pulling his fist back was was intentional. And I have to prove the parties were married at the time of the incident. I submit to you that when you go back there and you rely on your collective memories, when you take the evidence, when you view everything as a whole, I believe that you will return a fair and just verdict. Thank you.
Mr. Hadley.
Ladies and gentlemen of the jury, for bearing with us today. I know it was a long day. I want to hark back to what we started out with. What did you hear? What didn't you? What actually passed this instance? Now, we all know that if all it took was somebody to come in and make an accusation against somebody that they were angry with, any one of us, all of us could be charged at any point in time. So we know it's not that. We know that you need more than that. And we know that law enforcement responded that night. We heard from these guys today. They couldn't remember everything, but they did their job. They showed up and they gathered statements. And they gathered the available evidence that was there. Simply put, ladies and gentlemen, the jury, the only evidence that we have is a self-serving statement from an individual who had strong motive to lie. Now, I don't blame her for lying, and I'm not here to defend everything that came out of my client's mouth. As we've all said, we all say things, sometimes hurtful things to those we love. This is a marriage, as you heard evidence today, that had been broken down. It was not going well. And unfortunately, I even had a biological child of these two individuals who kind of got pulled into this mix. You can use your judgment, ladies and gentlemen of the jury, when you saw how everyone testified today, of how credible or how invested they seem. I truly, again, felt for the party's daughter. I don't think that she came in here today and wanted to be involved. I think when police showed up that night, her very minimal bare bones statements were pretty indicative of her reluctance to get involved. Ladies and gentlemen, you need to use your common sense when it comes to Carlos Fisher's testimony. If you listen to Mrs. Fisher, she'd have you believe that the only thing that her daughter did was all light your ass up. What we heard today was inconsistent testimony about where Carlos even was. Was she inside? Was she outside? We've already got a rogue fact that doesn't completely make sense on how she could hear something when she wasn't where it was being said. Maybe she heard it through a door, maybe she did. If you start finding yourself with maybes, ladies and gentlemen, you can move right to your verdict sheet, did not guilty. There's no room for maybes on this. I would say to you, ladies and gentlemen of the jury, it is not reasonable to state somebody was able to pull one little detail out of two people. And we did hear Carlos testify that she heard both of them screaming and yelling at the beginning of this. She was up in her room. She heard mama and dad yelling. She did testify that today. But the only thing she could remember was, I'll light your ass, which seems to be the only thing we've heard consistently from Mrs. Fisher the 3 times she told that story at me. So let's kind of back through that, because painfully, we all had to listen to the 911 call multiple times to refresh everybody's memory, to make sure that we weren't misrepresenting facts to you. So you had the truth and health evidence to make your decision today. What we know is Mr. Fisher is on trial for one is handbag and allegedly acting like he was going to hit his wife. We know that that's the crime that he's on trial for. There's been no charges about aggravated assault or attempted murder or anything to do with a gun. But what we know is for the 10-minute phone call, 911, there are allegations about name calling, about parking spaces, about people being rude. But we never once heard Mrs. Fisher make the allegation that he put her in reasonable apprehension of being struck or harmed. She never said it. And asks you, you can use your common sense why. Why, if that was the primary act that we find ourselves here in trial for today, why wasn't it important enough to mention? Now let's just jump past that. So Mrs. Fisher is told by 911, if you're in fear for your life, you need to leave the home. She admitted today she had every opportunity to leave the home, but that's not what it was about. Instead, she fired back with, why do I have to? Why me? Why, if he's the one who's being mean to me and being rotten, can't you make him go? Now, I'm paraphrasing slightly what was stated, but again, to sit here and not have you folks all listen to 4 hours of body worn cam, that's what we did. We cut and snipped and pulled these parts together into the important parts that we need. Ladies and gentlemen of the jury, 2 officers show up. Mrs. Fisher's on the phone with 911, hasn't left, hasn't sought safety, she's in her garage. Mr. Fisher's upstairs, left Alice is back in bed. As you heard officers testify in his bathrobe, and you saw yourselves kind of making his way back down from upstairs. What we know is Mrs. Fisher now has got her second opportunity to tell police what had happened. They show up. She starts with, let me tell you what's going on. She again walks through a very, very similar story that she told the 911 operator. Right? You know, we were bickering about the parking. Call me pretty unfortunate names. She even then told those officers new information she had told 911 about her motive, actually. I don't think she was thinking that she was telling the officers her motive to be maybe a little exaggerating or maybe even just untruthful about what happened, but she did. She went on to volunteer information, very private personal information about them, about their relationship, about alleged infidelities, about her wish to be out of a loveless marriage and move out, but it was a financial construct that was the only reason she couldn't. She's just listening for somebody who's listening, but as she's doing that, ladies and gentlemen, jury, she's laying out the motive as to why you cannot here and now take that statement as beyond reasonable doubt when it comes to evidence in a criminal case. We talked at the beginning of this today about the moms and dads of the panel. Hey, he's telling somebody's not answering. I don't think anybody today was staring down or looking away. But I would pose that when the questions became ones that the individual, Mrs. Fisher, didn't really want to answer, she didn't really answer. We had to go through a rigmarole, pulling up statements where she could remember what was said before, what was said after, but couldn't remember that specific statement until we more or less had to pull it out. And then and only then did she concede, okay, well, maybe that's what happened. I'm not blaming her, not here to do that, but just here for you to understand that there's a completely plausible another story. If there's a plausible second story, you must return the verdict not guilty. It's simply put right then and there that it's not beyond a reasonable doubt. Now, I'm not going to keep drilling on, and honestly, she gets a chance to stand up one more time than I do. I would love to be able to get back up one more time and keep doing this all day long with, because they have the prosecution. Such a serious high burden to me. She'll get one opportunity to get up and respond to what I'm telling you now. So I'm only going to leave you with a few more things. Now, we know that three stories about what happened that night were told. 911, she ignores the advice to leave the home, makes no mention of this alleged handcuffing and fake punch. We know that she's speaking to two officers. She's giving a detailed version of everything that had happened. We know that she makes no mention. We also heard Corporal Paisley, and I'm not saying that he was doing anything wrong, but we heard him admit he pretty well led her through filling out that form, the victim statement that you all saw. In fact, he regurgitated her story right back to her in a much more summarized version to kind of make it flow. And it was only then, that was the one and only time, if you go through the evidence today, that allegation about my client pulling his hand back to hit her, that was raised. I need you to think about that, and I need you to think about that part really hard. Reasonable, credible. Did this person have motivation to maybe fabricate or at least bend this in a light that looked favorable? And we don't blame her. We can even maybe understand how she got there. It doesn't change the simple fact that this man's freedom was on the line. And it's on the line on some statements that can't really be corroborated anyway. The closest we have in corroboration was the party's daughter coming forward and stating that she heard Elijah. What we know, it's quite possible she wasn't even in a spot. I'm blaming her, just know that we have testimony that says inside, outside, and it's going to be impossible to hear things in the manner that she testifies. There's a lot of questions that can't be answered. And it's not for any of us to speculate as to why the couple or the family has handled things the way that they have. But what we do have in front of us today, ladies and gentlemen, is a lack of evidence. There simply has not been enough put forward by the people to meet this very high burden beyond a reasonable doubt. Now, quickly, I do want to remind you back that when Mrs. Fisher actually very first spoke with 911, and the operator asked her, has he done anything to hurt you? And she parroted it back, do you mean hit me? And then I will clarify the operator, he clarified, he said, well, hit you or do anything to you. Ladies and gentlemen, if that question didn't beg the response of, he pulled back and acted like he was going to hit me, send help. I don't know what would. 911 was even ferreting out these answers, was asking the right questions, and it still wasn't the case. Now, the prosecutor raised the point about why do victims stay in dangerous situations? Ladies and gentlemen, what I'm telling you today, what the evidence is telling you, forget what I tell you. We're not talking about why would somebody stay in a quote dangerous or an abusive relationship. That's not even what the question is. The question is simply, If someone testifies to you under oath and tells you, I genuinely thought this person shoot you. Use your common sense, ladies and gentlemen. Sticks around. Who has the answer of, I'm not going anywhere, it's my house? The person who's not truly in fear for their life. That's who. So as you're, again, doing your deliberations and talking about what you heard today, ladies and gentlemen, I think it's very important that we do focus on that. We know that there was a new issue that had been raised at the very end about Mr. Fisher being taken away a vehicle. I think this is the first any of us had ever heard of that. Wasn't any police reports. First time it was brand new information. One more basis and motive of a really angry individual who was not access to divorce courts to resolve her differences with her husband, but instead used the criminal system to have Mr. Fisher removed from the home and less than ceremonious into the relationship. Ladies and gentlemen, heard the officer's testimony about Mr. Fisher's cooperation and his general mental state. You saw with your own eyes what he looked like as he walked down the stairs. I would ask you again, use your common sense and think about what a reasonable person within apprehension this individual is going to be, striking them, hitting them. You remember, Mrs. Fisher reluctantly, when she was being cross-examined today, and I'm sorry I have to do my job that way sometimes and interrupt, so that's not the question, but that's how this works. That's how we have to get to the truth. And when pressed on this today, what went from I was the only one catching insults to finally it was, well, okay, well, maybe I did say I was going to knock his head off too. So even as she was pushed today, she slowly started to give a little bit of ground. Now remember, ladies and gentlemen, you got a great looking sweater. The little string sticking off with it's no consequence. But when you start pulling on that string, you do start seeing the holes in that sweater. And I thank you for your time today to allow me to start pulling on that string to show you there's more here that we don't know. With that being said, ladies and gentlemen, thank you for your time. And I ask that after hearing all the evidence that's been presented to you today, of judging the credibility of the witnesses that you heard it from today, that you return the only right and just verdict, which is not guilty. Thank you.
Ms. Mannanek.
Thank you. I'm just gonna briefly address points that defense counsel brought up. So defense counsel emphasized that Miss Stacy Fisher did not tell the 911 operator that defendant had held his fist back because he was going to hit her. Again, I submit to you that the reason that she did not immediately state that to the 911 operator or to the police when they originally responded was because she was more concerned about the firearm because that is the bigger threat to her life. She did tell Corporal Paisley when she was giving her written statement that defendant pulled his hand back like he was going to hit her. But again, she was more focused on the threat to shoot her because, as she stated, you know, she can probably, or as Stacy Fisher testified, she can probably survive being hit by a defendant, but she can't survive being shot by a defendant. I think that's very important context when taking into account when taking into account when she disclosed the part about him pulling his fist back. Regarding Carlos Fisher's testimony, she testified that she was in the garage, walking back in. She said that she testified that she overheard her parents arguing. She overheard both of them arguing, or both of them yelling. And then she testified, I believe, she was standing behind the garage door when she overheard defendant say that he was going to, when she overheard defendant yell that he was going to light her ass in reference to her mother, Stacy Fisher. As I previously stated, I believe that when you look at the totality of the evidence, the totality of Stacy Fisher's testimony, the fact that portions of it are corroborated by Carlos Fisher, it's corroborated by a written statement, it's corroborated by the body cam that you heard and saw. I believe that you will return a fair and just.
Thank you both. All right, folks, home stretch, final instructions. If you want to follow along, that's what they're under, final instructions in the submenu. Starting with page 1, duties of judge and jury. Members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law. That is, I will explain the law that applies to this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors, who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. This is your job and nobody else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I have already given you some instructions about the law. You must take all my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way, to decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied, beyond a reasonable doubt, that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. Every defendant has the absolute right not to testify. When you decide the case, you must not consider the fact that he did not testify. It must not affect your verdict in any way. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. The lawyer's statements and arguments are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide the case from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during the trial. As I said before, it's your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have and not be influenced by a witness's disability, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how the case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. Moving into elements of the crime. The defendant is charged with domestic violence. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant assaulted Stacy Fisher. A battery is the forceful, violent, or offensive touching of a person or something closely connected with him or her. The touching must have been intended by the defendant, that is not accidental, and it must have been against Stacy Fisher's will. An assault is an attempt to commit a battery or an act that would cause a reasonable person to fear or apprehend immediate battery. The defendant must have intended either to commit a battery or to make Stacy Fisher reasonably fear an immediate battery. An assault cannot happen by accident. At the time of an assault, the defendant must have had the ability to commit a battery, or must have appeared to have the ability, or must have thought he had the ability. Second, that at the time, Stacy Fisher was the defendant's spouse. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about October 22, 2024, at 6112 Swan Lake Road in Romulus within Wayne County. When you go to the jury room, you will be provided with a written copy of the final jury instructions. A copy of electronically recorded instructions will also be provided to you. First, choose a foreperson. The foreperson should see to it that your discussions are carried on in a businesslike way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communication equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual, considered judgment of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. Possible penalties should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to Officer Krova. It is not proper for you to talk directly with the judge, lawyers, or other people involved in the case. If you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and full instructions. If you want to look at any or all of the reference documents or exhibits that have been omitted, just ask for them. When you go to the jury room, you will be given an electronic copy of your instructions you have just heard. As you discuss the case, you should think about all my instructions together as the law you are to follow. Joe will give you a jury verdict form as you walk in. I'm moving on now under submenu to evidence instructions. If you believe that a witness previously made a statement inconsistent with their testimony at this trial, the only purpose for that which the earlier statement can be considered by you is in deciding whether the witness testified truthfully in court. The earlier statement is not evidence. that what the witness said earlier is true. When the lawyers agree on a statement of facts, these are called stipulated facts. You may regard such stipulated facts as true, but you are not required to do so. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that the defendant had a reason to commit the alleged crime. She only has to show that the defendant actually committed the crime and that he meant to do so. Back to submenu, witness instructions. You should not decide this case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You have heard testimony from witnesses who are police officers. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. Counselors, are you satisfied with the instructions as given?
Yes, Your Honor.
Yes, Your Honor.
All right, folks, this is absolutely my least favorite part of the jury. There's 7 of you. Now, after you've all been so engaged and attentive, I'm going to kick one of you off. So you all know your number. So I've got 7 little beads in this can that are numbered. Juror number 4. Thank you for your service. Now, I will say this. When we're done, after we've got the final verdict and we share that with the courtroom, I'm going to go back and do what I call a debrief of the jury. I'd love it if you want to stick around, you can go back in there and get in on that final conversation. So I have a chance to answer any questions anybody has, a process and all that stuff. All right, but don't feel that you have to. I just want to make the invitation. Thank you, Mr. Tomlinson. All right, so with that, Joe can take the jury back in to deliberate, and we are in recess. Do you have anything in the back room you need to pick up? All right, usually I can tell by the fact that one person's holding paperwork. But there's a lot of you holding paperwork. So did you pick a 4 person? Sit, I'm sorry, sit. I would have been surprised if it wasn't, to be honest. Ms. Burnett, would you share with the courtroom the jury's verdict?
Hello, jury verdict, all 6 jurors, we said, we found him not guilty.
Thank you. Thank you. Any reason to poll the jury?
Just for formality, Judge.
Okay. All right. Ms. Burnett, your decision was? All right. And Mr. Zimmerman? Mr. Plesko? All right. Mr. Orban? Ms. Strong? And Ms. Gotro? Thank you. All right. Take them back in for me. You folks, once again, good job. You played well together.
Thank you,
Mr. Tomlinson, you can come back too.
Not won't smoke up your guys' backside. Thank you very much. These are, I know, it's gotta be tough and difficult. Well, specific thing. Attention. Somebody wake me by the end. Splashing water, so thank you.
You did a
guys.
very good job staying awake and paying attention. We're both very impressed.
Right.
Thank you.
Yep. Have a nice night. See you next time.
It's,
You want the days here? Good.
like, cycle. It's starting to, I'm trying to like, I'm in denial.
I can file too. And I'll probably still call you, like, answer the radio question. You're gonna have to